Welcome to In the Name of the Law with your host, Liisa Speaker from Speaker Law Firm. Joining her today is Sinas from Sinas Dramis Law Firm, along with Mary Chartier and Takura Nyamfukudza from Chartier Nyamfukudza PLC. Now let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law. In today's episode, we're going to talk about the causes of wrongful conviction, determining liability in car accident cases, and we're also going to get the perspective of a former judge on family law cases. Stay tuned.
In the name of personal injury law.
When we hear about a car crash, we often ask, who caused the accident? At-fault drivers are not only exposed to criminal liability, but they can also be sued in civil court for the injuries they have caused. Today we have with us Sinas, a personal injury attorney at the Sinas Dramis Law Firm, and he's going to help us understand Michigan law and fault as it pertains to auto accidents.
Thanks for having me.
So, why does determining fault for the crash matter under Michigan law?
So fault makes a big difference when you're looking at a crash for a number of reasons. First of all, for the people involved, if they are found to be at fault, they may face criminal penalties. They may have to appear in court. They may be charged with something like a traffic citation or even like a misdemeanor or potentially a felony. But that's criminal law. There's also civil cases that can be brought against at-fault drivers.
And those are the cases you work on?
Yes.
Yeah.
And so when a person is injured, they're trying to figure out what their claims are that they can bring in relation to their injuries. They have the right to potentially pursue Michigan no-fault insurance benefits. That's for the medical care, that's for loss of income for a limited amount of time. Those are payable regardless of fault. That's why they're called no fault. So actually fault doesn't really matter when you're talking about those benefits. But when you're talking about the person's pain and suffering damages, their long-term income loss that's not recoverable under no fault, those are the damages they can bring against the at-fault driver. So when they're considering whether they have those claims, they have to look at how did the crash occur, who did what, so we can determine whether or not fault can be satisfied for purposes of that civil case.
So tell us about comparative negligence when maybe both drivers are partially at fault.
Right. So when you're talking about how to determine fault and this concept of negligence, let me first start with the explanation in terms of the defendant in the personal injury case. The plaintiff brings the case against the defendant saying they failed to use reasonable care in operating their vehicle. There's a number of ways they can show that. They can show that the driver failed to follow the Michigan Motor Vehicle Code, that the driver wasn't paying attention, that the driver had an opportunity to stop or avoid the crash and they didn't. But it's all under this standard that the driver didn't use reasonable care. But the defendant can point the finger back at the plaintiff and say, you also didn't use reasonable care. I may have run the stop sign, but you were speeding. I may have turned out in front of you, but you could have seen me and avoided the crash. There are a number of different arguments they can make back to the plaintiff. I should also say that defendants can also say, yeah, I did something wrong. Yeah, I violated the Michigan Motor Vehicle Code. Yeah, I hit you, but there was a sudden emergency that I was confronted with, like bad weather all of a sudden, or I had a medical condition, or something came upon my path of travel that was unexpected. So yes, I was negligent, but there was a sudden emergency that negates my negligence. Mm-hmm. So there are these concepts that play into this analysis that can really be affected by the specific facts and circumstances of the case.
So does the injured person have to file a lawsuit in order to establish negligence?
No, not necessarily. What people should do is they should understand what the evidence is in terms of what happened in the crash, what the police said, what the witnesses have said, what they remember. And if the evidence really shows that another party's at fault, the injured person through their attorneys can contact that at-fault driver, and usually is connected then with their insurance company, and try to exchange information about the crash and get an assessment of fault that everybody agrees on. And even though they have adverse parties involved, when the plaintiff presents the information to the defendant's insurer before a lawsuit, the insurer might say, hey, we understand our person's at fault. We want to resolve this claim with you. Please present us the information of what your injuries are. We acknowledge that our driver was negligent, and some cases can get resolved that way.
So could you give us some examples from the cases that you've handled where the other side is claiming your client was comparatively negligent.
Right. So if you can't settle the case and fault's in dispute, the plaintiff goes forward and files the lawsuit. And in doing so, like I said, the defendant can point back at the plaintiff. And just to give the viewers a couple examples, I had a case where my client was driving the front seat and the driver turned left and shouldn't have, and then the car got T-boned. And it was nothing more than driver error in terms of her decision to turn left, but she had drank 2 glasses of wine. And when her defense lawyers got in the case, they argued that it was comparatively negligent for my client to get in the vehicle with somebody who drank 2 glasses of wine at dinner. The case was litigated. There was no showing from any toxicologist or any other expert that alcohol contributed to the crash. She wasn't swerving the lane. She just didn't see the car. And so we fought against this argument that, the defendant shouldn't have turned, but it's really my client's fault for getting in the car with her. I also have a pedestrian case where it was a hit and run, where the driver hit my client. She was not walking at a crosswalk, but she was there to be seen. And we were able to show through the lighting and everything else that was there on the roadway that the driver should have seen her and stopped, rather than she got hit and he drove away.
Right. So from some of the cases you've worked on, can you give us an example of where the other side has claimed that they had a sudden emergency that basically excuses them from causing the accident?
Yeah, one that comes to mind is a wrongful death case I handled for a Michigan family. Actually, the death occurred down in Florida, but the at-fault driver was on his way to get his prescription medication. He was a diabetic, and he had a seizure while driving. And so they initially argued that that was a medical emergency. He didn't know he was going to have a seizure. But we were able to show that he knew that he could have a seizure, and that getting behind the wheel, especially when he didn't have his medication, was a negligent decision. It was something he knew he had the risk of being susceptible to, and that's exactly what happened. He had the seizure and lost control of the car. So that's an example that comes to mind.
Well, can the defendant in the civil case blame other people, not your client, the plaintiff, for example, but other people who are around for the accident?
Yeah, so an injured person can sue an at-fault driver and make that person be the defendant in the case, but then the defendant can point the finger at non-parties and file what the law refers to as a notice of non-party at fault. And it's the defendant asserting in the case that it's not them, it's someone else. And when that happens, the plaintiff then has to make the decision whether they're going to add that other party to the case and bring them to the litigation. And that's usually what happens.
Well, can you give an example of where there's been, the defendant has tried to bring in a non-party at fault?
Yeah, one common example is when there's a showing that the person's airbag didn't work or some defect in the plaintiff's motor vehicle that contributed to their injuries. So the driver that hit them will argue, yeah, I hit them, but they would have not been as injured if the airbag worked. So they'll notice a non-party at fault, the auto manufacturer or whoever is responsible for the airbag. But one ridiculous one that comes to mind was a case I handled where the at-fault driver blew a stop sign, hit my client. She was doing nothing wrong, but he argued that he was frightened by somebody who had a bow and arrow in his hands on his own property on the roadway, and that he thought he was pointing it at him, and so he got distracted and didn't see the stop sign and drove into my client. It was a bow and arrow. He was in his car. But he filed the notice of non-party fault, and then we had to sue the person with the bow and arrow. But luckily, the case all fell back on the at-fault driver, as it should have been, because the facts didn't support bringing fault against the other person.
So when is it a good time to contact an attorney such as yourself to figure all these nuances out?
If you're seriously injured, you really need to consider your rights against the at-fault driver. If there's any dispute about fault in terms of how the accident happened, you need to make sure that you're collecting your evidence and building your case. So the more serious the injury, the more disputes there are in fault, the more reason there is to contact an attorney early on. Some people can go it alone, but I suggest certainly consulting an attorney.
Agreed. Thank you, Steve.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm. In the Name of Criminal Defense.
Criminal defense litigators Mary Chartier and Takura Nyamfukudza of Chartier Nyamfukudza have talked about individual exonerations on prior episodes, but today we're going to talk about the causes of wrongful conviction. So, Takura, your firm has helped to exonerate a number of people, I think 6 at least, who are now on the National Registry of Exonerations because of the work that your firm has done. And you've also gotten a wrongfully accused dog free from conviction as well.
Four dogs.
That's right.
4 dogs. Wow. So let's talk about people though. How frequently do wrongful convictions actually occur?
So before we start talking numbers, let's be very clear that these are actual people, right, who are impacted by these blunders, and many of them are intentional actions. But since in 2021, the National Registry of Exonerations tells us that 161 people in 1 year alone were exonerated. And since 1989, which is within the lifetime of everyone in this room, 3,331 people have been exonerated. That equals to 291,000 years lost, Liisa. Now, in capital cases, which in Michigan, fortunately, because we don't have the death penalty here, capital cases in Michigan are ones in which a person could draw their last breath behind bars, but in other states, Texas, you could get executed. 5% of those cases result in exonerations. And for the non-capital offenses, 6% of those result in exonerations.
And there are a lot of researchers, just to jump in, who think that number is actually bigger. So one of the problems is DNA is not prevalent in every crime. There are a lot of cases where there's no DNA, and a lot of the exonerations, though, are DNA driven. So then you can clearly rule somebody out because their DNA does not match that under the person's fingernails or inside their body or whatever it might be. But if you're in a situation where there's no DNA, a lot of people believe that number is significantly higher, but there's just no way to clear the individual who's in prison.
So can you explain to me what are the primary causes of these wrongful convictions?
So they've been narrowed down to 6 primary categories. Number 1, witness identification, and that involves perjury and whatnot. A second one is inadequate defense by defense counsel, unfortunately. False confessions, believe it or not. People will, under the right circumstances, give a false confession. Additionally, flawed forensics, which we've talked about many, many times. Bias, and of course, misconduct, government misconduct by law enforcement personnel and prosecutors.
Well, let's start with flawed forensics. What is that?
So Takura mentioned we have spoken about that on the show before, but we've really targeted particular areas. Flawed forensics is a really wide area. So you've got things that people think of as science. So a lot of people have watched at some point CSI on TV. It's been on a long time. I think it came back on again. Things like DNA, but then there's also things like fingerprints, arson, bite analysis, hair analysis. So bite analysis, hair analysis are 2 areas, for example, that have been really disproven as being based in any real sort of science. When they've done testing on that, you could flip a coin and get the same percentage of being correct as people come in and talk about. Then you have areas like abusive head trauma, which a lot of people may know as shaken baby syndrome. And we've exonerated 2 individuals who were in prison, convicted for supposedly shaking their baby to death when that's not what the science supports. That was challenged for years and years, stating that the science is incorrect. And only really now have courts started recognizing that the science behind that is flawed. Then you have things like DNA, which is still relatively new in a lot of respects, especially what's called star mix DNA, which is actually an algorithm. So you see that when there is a mixture of DNA. So you see that, for example, if you have a DNA sample that might be 2 or 3 or 4 people, and the lab analyst has to essentially come up with a hypothesis and say, okay, well, if it's 2 people, it could be 3 people, it could be 4 people. And then it's essentially an algorithm that they try to figure out who it is. And then you have these are called soft sciences, and I think science might even be too strong a word, where you have people saying, okay, this happens because of trauma. And we had a case where the government's expert said essentially that any characteristic of a teenager was indicative of that person being sexually assaulted. So if the person was struggling in school and acting out, lying, using drugs, that's a sign of trauma. If the person was a 4-point student, a star athlete, that was a sign of trauma because the person was trying to make their life perfect. And if it was just your regular old teenager, not top of the class or bottom of the class, that was a sign of trauma because the person was just trying to fit in and be normal. So you have a lot of experts, and I should use air quotes for that, who come in and will testify. And really the solution is courts to be gatekeepers on that.
So we've done an episode with you on eyewitness identification. What is the problem with eyewitness identification?
Well, that episode, along with others, is available on our website, cndefenders.com. But these witnesses are called on, and of course, not every case is a homicide, but these witnesses are called on to testify from memory, and memory is very malleable. I mean, if you ask me what I had for breakfast 3 days ago and what color socks I wore, I don't know that would ever come up in court, but memory is malleable, and there are actual experts on that too. So in a lot of these cases that get overturned by post-conviction DNA testing, they're based on memory.
So what makes that category so susceptible to producing wrongful convictions?
So you have people who think that if they're on a jury and someone comes in and says, that's the person who did it, right? And they point to the defendant sitting at the table, and they'll say things like, I'm certain, I'd never forget that face. You have a jury who really kind of buys into that and doesn't understand the science behind flawed witness identification. We've all done it, right? We all think we recognize somebody on the street and you do the hand wave and then it's not that person and you have to kind of awkwardly put your hand down. In trauma situations, when someone is being assaulted or you see someone fire a gun, that doesn't make your memory more certain. And so what studies have shown over and over again is that certainty has absolutely nothing to do with the ability to remember an event or the ability to identify someone. And one of the biggest problems is how law enforcement will obtain an ID. In some cases, they'll do a show up. They'll grab the person who they think is the suspect, and then they'll walk them over and the person IDs them, or they'll do a 6-pack when really they should be looking at photographs individually. So there are a lot of things that really our state needs to be doing in our entire country that are not being done. We know people are being wrongfully convicted, yet the state is doing very little to nothing to actually address these issues. And as you know, Liisa, we cover all these issues on our podcast, Constitutional Defenders, and we have CN Defenders website where we have sessions on false confessions and everything else that we've talked about here today.
So we don't have time to dissect all the different areas where there's flaws, but are there other categories of significant flawed forensics that we need to be looking at in the future?
So beyond flawed forensics, as Takura talked about, we've got issues of bias that happens in the court system, as well as lack of resources for the defense and government misconduct. So you have really a situation where a lot of times courts, unfortunately, and juries are just accepting what the government has presented to them and not really analyzing, does this make sense?
It sounds like we have a lot of future episodes.
We certainly do. We certainly do.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza, PLC. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Family Law.
We're here today for the Family Law segment with a very special guest. I want to welcome Amy Krause. Now, Amy has a very diverse experience. She started off as an attorney at the Attorney General's office, so she was litigating cases, and then she became a district court judge. Then she went to the Court of Appeals. So after 20 years of being on the bench between the two courts, she came back into private practice and is an attorney here at Chartier and Nyamfukudza. And so, first of all, welcome, Amy.
Thank you. Thank you very much for having me.
I suppose I should call you Judge Krause, but now you're going in front of judges. I think that might be confusing, so I'm going to stick with Amy for today.
That's fine.
But I think the perspective that you bring to the table, and especially for family law, is that you've seen so many things about how witnesses act on the stand from when you were a private litigator for the state and when you were a district court judge, how you see it when you read a transcript when you were on the Court of Appeals. So I wanted to start off by asking you about the things that you are observing like when you were a judge, what types of things did you observe in witnesses or parties who were testifying that, made you gave you an impression about that person?
Well, there were so many things because it's really sort of like talking to anybody else. You sort of know when people are telling you the truth or not telling you the truth in general in life. And the witnesses, you have to account for the fact that they may be nervous, because that is a pretty normal thing. You have to account for what they're testifying about. It may be something that's really personal and very, very difficult about which to speak. So you need to keep that into your thought process when you're dealing with whether or not they're actually credible or not. So those are all things that you'd have to look at when you're the trial judge.
And then if you could just compare a little bit about how you looked at witness testimony as a Court of Appeals judge, how that differs from when you were on the trial court bench.
Well, the difference is you're reading their testimony when you're on the Court of Appeals. You read the testimony in the transcript. So for me, I really relied on the trial court's rulings in terms of their credibility rulings because I wasn't in the courtroom. So for me, particularly, I remember a case, one of my very first cases, where I dissented because the trial court had ruled one way about credibility, and my colleagues said, "Oh, that can't be right. The trial court got it wrong, and it should be the other way." And I said, "Well, isn't the trial court? Aren't we supposed to give deference to the trial court's rulings on credibility?" And so I ruled the other way. And the Supreme Court, I'd only been there for 4 months, and the Supreme Court ruled 7-0 that I was right and adopted my dissent. So,
vindication?
It was a little bit of vindication because I was pretty new, and I thought, well, I think I'm right, so I'm just going to say this. So
but that you got that perspective from having sat on a district court bench.
Exactly.
So I'm going to ask a question. I didn't warn you about this, but it's going to be a little bit controversial, I think, in the future. There's a lot of conversation about Zoom trials and whether, and some judges there's a diverse set of opinions about whether those credibility findings that you can make from watching somebody on Zoom are any good, or whether it's the same as having them in person. Do you have any insight or thoughts on that?
Well, I think Zoom has its place. I think that there is a real place for that. I think oral argument is certainly a place where we can have Zoom, particularly when someone is suffering from COVID or they've been exposed to COVID. I'd much rather have them be on Zoom when I was on the Court of Appeals. If they told me they had been exposed to COVID, I said, absolutely be on Zoom. I think it's a different matter when you're dealing with a trial. When you're dealing with a trial, particularly a jury trial, even a bench trial, to be able to tell somebody's credibility through Zoom, I think that's really tough. I also think it's tough to know what else is going on in the room because we can't see what's in the room. We can't see who's in the room. So particularly thinking about a domestic violence case or a assault with intent to do great bodily harm case, or even a family law case, when you're dealing with something as intimate as domestic violence in a family law case, and you don't know who else is in that room with them, because they could be in the other room and on Zoom themselves, and we would never know it. So I think that's a very, very hard line to pull. I really do.
So I'm glad you brought up domestic violence, because one of the things I think that came out of your tenure on the Court of Appeals was you had so many opinions, and sometimes they were dissenting opinions because you couldn't convince the rest of the folks on the panel to go with you, but you had so many strong opinions about domestic violence and how it should be treated in family law cases, where I think sometimes other judges don't necessarily recognize the symptoms of domestic violence and maybe the way people act when they have survived some sort of domestic abuse or coercive control. Can you talk about that a little bit?
I sure can. And it's interesting because I thought of a case that really I felt very strongly about, and that was that the definition of domestic violence under the state Domestic Violence Sexual Assault Prevention and Treatment Board actually talks about animals being abused. But that's not anywhere else in any statute, but it is the definition of domestic assault in that area. So for me, when I saw a case dealing with animal abuse, I called it domestic violence, and I could convince one of my colleagues, but not both. But we were able to change that definition. So if the person is abusing animals in a domestic case, not in a domestic violence case, because then you're dealing with a completely different statute, but in a domestic relations case, if there's abuse of an animal, that is domestic violence that the court can take into account.
Yeah, well, they're using it probably for control purposes, right?
Exactly.
So another thing, well, as you know, a passion of mine is getting trial judges to follow the law. And so I know you on the Court of Appeals had opportunities to see where judges weren't following the law. And the idea is that the Court of Appeals will fix that if you can convince your colleagues to go along with you when you see that sort of thing happening. And I know you have some memories of this happening, a lot of cases that you saw.
There were so many cases where I think that it's easier to talk about parenting time than it is to change custody. And if you change custody, then you need to go through the Vodvarka factors. So there were many times that I would see cases where it would be called a change in parenting time, and really it was a change of custody. So they didn't go through the Vodvarka factors. They just did the change of parenting time, and it made it simpler for the trial judge, but it really didn't make it simpler for the children that were involved, because then it had to come to us. We looked at it and said, no, it has to be a Vodvarka issue. We have to send it back. Now everything's been delayed, and these children have been in the wrong place for a period of time, which is so hard for them.
Right, exactly. And I'd be remiss not to point out that now that you're back in private practice, you are also doing family law mediations.
I am.
And so I don't know if you have any closing thoughts about, the idea is not to have to go to trial. The idea is not to have to go to appeal. Tell us about the role of family court mediation.
Well, family court mediation, I have found that it is, I in fact just got certified through the class. I'm about to take watch my 2 observations that I have to do. And I am finding that everything I've learned means that people can come to an agreement together, and I can facilitate that. And if I can facilitate that, then it's not a judge telling people what to do or what they have to do. In fact, they can come to an agreement through some assistance. And I really believe that I have that ability after being a judge for 20 years to be able to help them.
Right. That increases the likelihood that maybe both sides will give it more weight to what you have to say because you've been in that role for such a long time. Oh my gosh, that was so helpful. Thank you, Amy Krause. We're so pleased that you were with us today.
Well, thank you, Liisa Speaker, for having me.
In the Name of Family Law is brought to you by Speaker Law Firm.
Thank you for watching In the Name of the Law. We'll see you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.